Okay, so today we are going to talk about home inspections under the NABOR and FRBAR contracts. I am, like I said, excited about this presentation because it's got my new slides. I hope that you enjoy them. And if you have any questions, of course, just unmute yourself and shout them out or type them into the chat. I've got it up on my screen. As always, when I do these webinars, we start off the morning with a disclaimer. I'm an attorney and we're not creating an attorney-client relationship. If you have any questions about a specific client, you can always call me afterwards. A little bit about me. I am been an attorney now for 20 years, which is a little bit frightening. I specialize in real estate law. I serve on the committees that write these contracts and oversee these contracts, so I know them very well. And my firm is primarily a real estate and business firm. We also litigate, and our goal really is to provide common sense
How do I know if the videos?
people with their issues. So today we're going to review the inspection provisions. We're going to compare the NABOR and FRBAR contracts. We're going to talk about defective versus cosmetic conditions and what must be repaired. This is a pretty focused webinar. We're going to talk about how the inspection provisions are different depending on which contract you use, the type of inspections, how long the seller has to make repairs, and what happens if the seller disputes an election report. You know, these are essentially the three topics. The issues are negotiated by virtue of the form picked. So you should always feel free if somebody comes in on a FRBAR contract to counter on the NABOR form or vice versa. One thing that's interesting for related to today's topic is that the default is 15 days to do inspections in both contracts. But again, both have blanks for negotiating them. So we're going to dive right into the forms this morning. Now, I want to say before I even start with the forms, we're talking about the contracts that are require the buyer to go through the inspection process to protect their deposit. We are not talking about the as-is contracts. The as-is contracts are very simple. The buyer gets the inspection period to make a decision whether they want to move forward or not. And then they either move forward or they terminate within the inspection period. So we're not talking about as-is contracts today. We are talking about the standard contracts. And then just looking here, the FRBAR contract is obviously a very widely used contract across the state. It contains three main inspections: your general inspection, your WDO inspection, and your permit inspection. And then you can add an addenda for mold. Interestingly, this contract does not have a radon option. Not sure why, but it doesn't. Sellers under the FRBAR contract must make the required repairs within 10 days of written notice, or they have to provide estimates of those for their version of the repairs. And under FRBAR, there's a procedure that says if my report doesn't match your report, the buyer's report doesn't match the seller's report, and there's a discrepancy, then the parties hire a third inspector, and that inspector's decisions as to what is defective are final, and that's what the seller has to repair. But remember, under FRBAR, the cost of repairs are capped at 1.5% of the purchase price by default. That default can be changed. There are blanks in section 9 of the contract. And if the repairs exceed the repair limit, then either party has to give notice to the other party of their willingness to move forward, or the parties can terminate the contract. So there is an out in the FRBAR contract, the standard contract, when the repairs can't be agreed to and properly resolved, we'll say. And it's an interesting thing under the FRBAR contract. The seller must replace torn screens, fogged windows, missing roof tiles or shingles, and things of that nature. Um, it's in my opinion, I'm giving an opinion here. This is not the judge's opinion. It's my opinion that the FRBAR inspections, they're a little bit more concise and clear as to what has to be repaired. Now let's compare the NABOR forms. Under NABOR, you get 6 inspections: systems and equipment, radon gas, lead-based paint, wood-destroying organisms, mold, and open permits. That's very interesting. In the NABOR contract, the systems and equipment has a really broad definition, including the property, all appliances and equipment, fire, sprinkler, irrigation, wells, septic, heating, cooling, electrical, plumbing, security system, mechanical components. A very comprehensive list of what is systems and equipment. All the mechanical components of the pool, the foundation, the roof, the walls, all are included in the definition of systems and equipment. So you get a very comprehensive inspection provision in NABOR. Under NABOR, the seller is limited to paying for the fair market value of the items as if they were in working condition. It's interesting though, because the seller doesn't have a stated limit as to the amount of money they have to pay for the inspection items. Again, the NABOR also provides forms for the inspection process. Basically, you make an election. The buyer either can decide to have remedial action taken, they can decide to have a credit, or some combination thereof. And the seller is required to make a diligent effort to complete the remedial action, or estimated costs have to be escrowed. And it's a 200% escrow based on the written estimates that the buyer has provided. One interesting point about the NABOR contract: if the buyer, on the one hand, thinks that the disposal's not working or it's too loud, and the seller says, nope, it works fine, it grinds the food and it goes down the drain doesn't clog, there's no procedure in the NABOR contract for disputing that. So the realtor really becomes more important in the NABOR contract in this regard. You're going to have to work together between the listing and selling agent to get the process moving, so to speak. There's no way to just bring in a third inspector. It's a matter of negotiation. The oven light doesn't work. Okay, that's obvious. But the oven heats. Do we replace the light bulb? Well, probably. Things like that could come up in inspections. Try to think of another good example. But the point is, you become much more important as a realtor because you have to help through the process. It's not just the inspectors, the dueling inspection reports of FRBAR. Interesting, in the NABOR contract, the seller is not required to repair or replace torn screens, minor window cracks, or cracked roof tiles. So it's a little different than the FRBAR contract. So both contracts require certain systems and equipment to be in working condition. If they don't pass the buyer's inspection, the seller is required to bring them into working condition, or risk that the buyer will walk from the contract. They risk termination. Other conditions on the property are cosmetic, and the seller is not required to repair them, even though the buyer may ask. There may be a negotiation. But what is in working condition and what is cosmetic, again, depends on the contract. Systems and equipment must be in working condition. That means operating in the manner in which the item was designed to operate. And that's by the manufacturer. So going back to the example of the disposal, if the seller has the whisper quiet disposal in their house and it's not whisper quiet, then it's not operating in the manner in which the item was designed to operate. so the seller has to repair or replace. But sellers are not required to repair cosmetic conditions, which are defined as aesthetic imperfections which do not affect the working condition of the item. And the contract goes into detail as to what needs to be maintained and how it has to be maintained. So under FRBAR, you have to maintain the items in working condition that be free of leaks, water damage, and structural damage. And that's the ceiling, the roof, the walls, the doors, the windows, and the foundation. And it defines in the contract that these specific items have to be, again, free of leaks, water damage, and structural damage. These items have to be maintained in working condition. You've got your pool and pool equipment. Of course, it should pump water. Your appliances need to work. We talked about the disposal or the oven. The HVAC's got to work within the tolerable limits. You know, you've got your, they put the plugs in the either side of the air handler, and it's got to cool the heat or heat the air. The mechanical systems have to all work. Your electrical. These are the items that the contract specifically maintains in working condition. We talked about this. If the under FRBAR, torn screens, including pool and patio screens, have to be replaced or repaired. Fogged windows. I'll say this about fogged windows. I've dealt with fogged windows a number of times, and you're basically replacing fogged windows. I've never seen it where they can repair a fogged window. And then missing roof tiles or shingles have to be replaced. Cosmetic conditions under the FRBAR contract, pitted marcite, that's in the pool, tears, worn spots, discoloration. One thing that's very interesting here, pull up my highlighter. Minor cracks in walls, floors, floor tiles, windows, all these things. What's a minor crack? There's no definition of minor crack. My argument when I have the contract is if it's structural, it's not minor. So you look at, you know, the seams in the wall that come down where the stucco is cracked. If the stucco is cracked, it's probably minor. If the block is cracked, it's probably major. So you got to look and figure out. And again, this is where your experience as a realtor is going to come in, because you're going to have seen multiple properties and multiple minor cracks and know the difference. I've had realtors say if it's greater than ½ an inch, it's major. I don't know if that's the case, because if it's a ½ an inch crack in a driveway, is it a major problem? Probably not. It's probably not structural. But if it's a gaping hole or in the floor of the house, a ½ an inch crack, then probably needs to be fixed. So cracked roof tiles are cosmetic under FRBAR. Well, as I said before, missing roof tiles are defective, but cracked roof tiles under FRBAR are simply cosmetic. And then limited roof life is cosmetic so long as there's no actual leaks, leakage, or structural damage to the roof. So I'll say this about your inspector. They've got to get up into the attic if they can. They've got to look and make sure that there's no structural damage. I see this missed a lot. We've had 2 major hurricanes come through Southwest Florida in the last several years. So getting your inspector up in there and having them look at things is really, really important, obviously. Switching over to the NABOR, what must be in working condition, which means structurally sound, watertight, and free from wood rot. Your roof, your ceiling, your walls, your foundation, your pool, your spa, and your pool decks. Structurally sound, watertight, free from wood rot. So I've had it a couple of times under the NABOR contract, more than a couple of times, where people will talk about the soffits and the fascia underneath the roof, and it gets the wood gets rotted away there on the roof. And I've made the argument both ways. I admit that when I have the seller, I don't want to fix wood rot in the roof, but it is part of the contract. It has to be put in working condition. So I would argue under NABOR that those that wood rot in the fascia of the soffits is going to have to be fixed. Another thing about NABOR, what has to be in working condition, it requiring the seawall, the docks, and the pool and lanai enclosure, your screen, to be structurally sound. So your seawall can't be tipping over or cracking in a major way, or your docks have to be solid, and your pool and lanai enclosures have to be structurally sound. It's very interesting to me, especially after the hurricanes. A lot of people got their pool cages replaced, and that's great, but I never see in the inspection reports where anybody checked the pool cage. They look for the rusty screws around the pool cage sometimes, but rarely ever do I see that someone checked to make sure that the pool cage is properly attached to the fascia. It's interesting to me post-hurricane that doesn't happen that often. When I bought my house, I did have that done. So what's cosmetic under the NABOR contract? A lot of things. The seller is not required to repair or replace corrosion, tears, worn spots, discolorations, missing and torn screens. So like we said in FRBAR, these are defective. They are in NABOR cosmetic. Nail holes, scratches, dents, chips, and caulking. I always get asked, the seller moved out, they left a bunch of junk, or not junk, but dents and scratches and nail holes in the walls. I want to escrow my 200% and get those fixed. Well, you can't. It's specific in the contract to be a cosmetic condition. Pitted pool surfaces, that's that Marsite again. Again, with the minor cracks in windows. So cracked windows do not have to be replaced under NABOR. I think that's very important because talking again about the fogged windows, which are not addressed in NABOR, usually fogging comes from cracking, and that will be a minor cosmetic, a cosmetic condition under NABOR. Again, cracked roof tiles. This is actually similar to FRBAR in that the cracked roof tiles don't have to be replaced under FRBAR. Missing roof tiles have to be replaced, but under NABOR, they do not. Then, of course, curling and worn shingles, limited roof life, as long as there's no evidence of structural damage or leakage. Basically the same test under NABOR and FRBAR for when you have to fix the roof, whether it's leakage or structural damage. But they do have the minor, again, without the definition, which drives me crazy. So just to wrap up here, what is better? And again, I've said this in all my webinars, I think. It depends on the situation. It depends on the people. It depends on the contract. What's the condition of the property? I mean, when you're standing out front of the property, you can look and see if there are missing tiles on the roof or missing and worn and folded up curling shingles. So maybe you want to go with the contract that requires that to be replaced. Maybe you write it in specifically if the buyer is sensitive to it.
Hey.
Yes. Catherine, you had a question? Okay. Look at your party's priorities. You've got to obviously know your property if you're the seller, but if you're the buyer or the seller, you've got to know what your priorities are. One thing that comes up a lot is mold, and FRBAR has a mold addendum. NABOR says that you can inspect for mold, but it excludes penicillium aspergillus and other allergenic molds as defective items. Well, I can't tell you the number of times that I have had a buyer come to me with a mold sensitivity and say, I need to get out of this contract. They found mold. I can't live in a house where there's mold. And I have to say to them, if you're in the NABOR contract, I say, well, the mold test doesn't allow for allergenic molds to be defective. And It only looks to whether there is more mold inside the house than outside the house. So that's a tough conversation to have with a person with a mold sensitivity. The other thing to think about, does the buyer want to force the seller to make repairs? If the seller doesn't want to make repairs, then you're going to negotiate which form to use, because under FRBAR, the seller has to make repairs up to the repair limit. Under NABOR, the seller can reject the inspection election and the buyer can walk away. And then as a last point here, you can always modify the contract. You need an attorney to do an amendment or an addendum, depending on where you are in the process, but you can always make modifications. I know you are told as realtors, do not mess with the pre-printed language. I guess as an attorney, I'm allowed to do that. So if you ever have issues, you need things fixed in the contract specific to your property, we can always make those changes. Sam is asking, missing and torn screens, is there a conflict with FHA, VA requiring screens to be okay? Sam, I am not 100% familiar with the FHA and VA requirements with regard to pool screens, but if you have a loan under, I assume you're talking about under the NABOR forms, if you've got a loan and you have not waived your finance contingency and the loan is going to be denied because there's missing and torn screens, then that's a conversation that the buyer and seller through their realtors need to have, and you need to make a decision on both sides about how you're going to move forward. Stephanie, you're asking me about old electrical outlets. I assume you're talking about replacing old ones in the kitchen and bathrooms with GFCI outlets.
Yep.
And you've got, the property has to come to code. The question is, if the property was built, pre-GFCI, do you have to replace them? And I always tell my buyers that it's a life safety issue. I tell my sellers it's a life safety issue as well, and it's got to be brought to code. So that's how I handle GFCI outlets under both contracts. Now, sellers hate that, and it's questionable, but it's a life safety code. And I would say if I'm a buyer and the seller doesn't want to fix the GFCI outlets, we're going to have a serious conversation under NABOR. Again, the seller can just say no, and the buyer can terminate. Under FRBAR, I would say it's got to be fixed, and it's up to the repair limit.
Mm-hmm.
Bob is asking, when is a good time to get your buyer to talk to their closing attorney to address some of the things we were talking about today? Bob, it baffles me that realtors are so afraid of attorneys, and maybe it's with good reason, but it's not the way I operate, that they're afraid the deal's going to fall apart. But I would bring your buyer and your seller to their attorney as soon as possible to discuss the implications of what they're signing. You're not supposed to give legal advice, but you can advise on the contract. But I would say as soon as possible in the process. Once you meet your buyer and you have your conversation, hopefully you're getting a buyer broker agreement signed now. And then you say to them, listen, I've got this attorney. I want you to meet with them. They are going to talk to you about the contracts and the process for closing and marketable title. So I would say as early as possible in the process. Get your buyer with their favorite attorney, preferably me, and we will walk them through. And the way I approach it is, it's not about blowing up the deal. Obviously, I want the deal to go through. I want the buyer to be comfortable and understand what they're signing and understand the process that they're going to undertake, because I recognize how stressful it can be. So those are my comments on the inspection items in the two contracts, and I will take Any questions? Miles, what's the average cost for the use of an attorney? Miles, typically my fee is between $650 and $850 to do the closing. It's a flat fee. I don't charge junk fees, and it's pretty much all you'll pay me. The buyer will pay for title, the seller will pay for taxes under both contracts, depending on the county. Any other questions people have?
Sam,
Yes, ma'am.
we have some of the homes that have wicking outside going up the stucco. And I'm not really sure what causes it, but it's a permanent line.
Wicking?
Like a stain, wicking, like water.
Wicking. What's wicking?
Like water going up the stucco, probably about 2 inches, 3.
Going
It's
up
like
the
a
stucco?
stain. Yes, going up the stucco from the outside.
You said as a stain?
It looks like a stain.
Again, you've got to look if the structure is structurally sound and watertight. I think you're looking at a cosmetic item. If the water is getting into the property, to the interior of the property, then you definitely have a structural issue. So
Okay, so it's going interior, then okay. Thanks.
I'm not sure I fully understand wicking, other than the water. If the water is going up the side of the building, it must be driven or something. I'm not sure, but if it's structurally sound and watertight, then it's going to be a cosmetic issue.
Okay, thank you.
Miles, yes, this is recorded and I will make it available on my YouTube channel. Other questions? Thanks, Mike. Any other questions? I have a question for the group if you want to unmute yourself. Do you like the shorter, earlier webinars, or did you like the 2-hour ones with the whole contract?
Shorter, earlier.
Shorter's better.
Shorter,
Yes.
shorter, earlier? Okay.
Yes.
Well, by the fact that you're on this shorter, earlier webinar, maybe that means you're biased. Excellent. Well, I really appreciate everybody coming out today. It's an early morning. If you have any questions, please call, email, text, whatever you need. I'm looking for any feedback that you can provide. I see we have 1 vote for longer later. Jackie, you got it. And you can always get them on my YouTube channel. Thank you all very much for coming in today, and I will talk to you all soon.
Thank you.
Thank you, Sam.
Bye, Sam.
Thank you.